Today is going to be kind of a primer. I'm going to run through a lot of topics that I oftentimes spend an hour presenting on each one of these topics, and my goal will be to not take up the rest of the afternoon. We all know that the agricultural system is under severe criticism. There's been a lot of escalation in the tone in recent years. It's become a lot more vocal, a lot more strident. And I think the public is a lot more susceptible to these sorts of pitches. It seems to me that we have become much more urban, much more suburban, and much less rural as a country, and much less connected, as the video that we saw earlier today demonstrated. And that makes us so that we're willing to listen to some of these arguments that really aren't based on science and the real world. I hesitate to say this because it will show how boring my life can be sometimes, but recently I've been watching some of the Travel Channel shows, and I've found it kind of refreshing that some of those shows paint a more realistic picture of what the real world's like and what it means to get your own food and what other cultures do with food. And I think it's helping for those who watch it understand that there's a lot more to it than it just showing up in the grocery store. I'm going to talk today about how activists can misconstrue or distort claims and some of the approaches that we've been seeing recently. I'm going to talk about how litigation can be meant to serve a bigger or more covert agenda, although I'm going to flip that a little bit. I think litigation oftentimes is the agenda. Talk a little bit about how nuisance lawsuits may increase or decrease as food production evolves, and some of the recent cases and theories that we're seeing. And then I'm going to talk a little bit about product safety liability and how producers might help minimize or reduce litigation risks, and then some overarching legal issues that producers need to be aware of as they expand and concentrate or just continue their operations. This is a little bit of a diagram we put together that kind of models what we're seeing a lot more often with respect to litigation, and how activists are inviting comments, riling up the public, and then passing those folks on to litigators and attorneys. This is kind of a typical model that we're seeing where plaintiffs' attorneys continue to look for issues. They either have an expertise in it or they're looking for other issues. It can involve some sort of claim of purported disease in a certain location. It can involve certain kind of chemical or odor exposures. And what we see them doing is gathering additional information, setting up public meetings, saying that they're going to gather additional information, encourage people to communicate, publicize the investigation, oftentimes get the media involved, get a lot of attention, emphasize that they're just gathering information. They're just trying to help the community. They're not trying to scare anybody. They de-emphasize litigation, say that's not what our focus is going to be, that they're just fact-finding. Oftentimes these meetings, there's a lot of sympathetic folks who try to connect dots. Oftentimes there's really no connection, but they think there's a connection. So it's a very sympathetic crowd, and it can really create a lot of synergies with respect to those folks. And they feed off of each other's, and that's the dynamic of the meeting. They continue to encourage communications via email to their websites. They publicize the investigation into the alleged problems. They say they've already done a lot of work. They start talking about a lot of information they say they've gathered, whether they really have or not. They discuss ongoing testing. And then they promise to publicize the results of the testing and investigation, although they never do. And ultimately, when it ends up into litigation, they won't produce that information. They try and hide that information. And then they try to hide the folks that were involved in it as being part of the attorney team, so you can't ever get to the information they say that they prepared. And all of this kind of tends to rile up the public. It's kind of a nice situation because it riles up the public. It gathers the plaintiffs, and the plaintiffs are passed on to the legal team to become plaintiffs, and at the same time, you're influencing the jury that might ultimately hear that case because they're hearing about all the publicity. We've worked with a lot of folks in either defending once this kind of thing happens, or when we know it's about to happen, in working with clients on how to react and prepare for these kinds of meetings. Here's some other activist group types of activities that I'm sure most of you are familiar with, but it all helps to influence the environment, set the stage for what comes next. Here's an example of the Physicians Committee for Responsible Medicine suing the USDA about their dietary health guidelines, and they basically are going after agriculture. That's their focus. It's a vegan, a preventative medicine group that is saying that USDA has ties with agriculture, and so there's something wrong with what USDA is doing. They've become very aggressive and very direct in their approach. Other types of activities that we're seeing, obesity litigation. There was a lot more attention to this earlier, and it's maybe died down a little bit, but it's not over with. There are a number of groups that are very active on this. They're they're considering litigation on the obesity issue, and all of that helps taint the environment. It helps make it look like big food is doing something wrong. It's planned, it's focused, and there will be more of it. Animal litigation to abolish animal agriculture. Here's a statement here from the Humane Society about litigation being one of their tools to stop animal agriculture. Example of a Humane Society member suing a farm for misleading consumers. Kids are a target. Kids and food are a target, and you'll likely see more of that. And then other kinds of consumer fraud types of claims. And we'll talk a little bit more about this later, but here's some examples of claims against the food industry. And some of these are animal claims too. Most of this is just other kinds of food. And here's some other examples, again, of recent cases against various groups, normally misleading consumer types of claims. In the nuisance arena, we're seeing claims in nuisance. This is an example in Missouri that we've been dealing with recently. Claims of nuisance against Premium Standard Farms, which owns a number of CAFOs in North Missouri, asserting order and water runoff claims. And one of the things that they do, and we've seen it here, is that they'll play off the local laws. In this case, in Missouri, they're using temporary nuisance, which means they get to sue over and over again after a certain period of number of years, so the litigation never really ends. We're also seeing different theories so that they can collect more than the property value is worth in these kinds of claims. And then in Missouri, it has led to legislative efforts to try and prevent these kinds of lawsuits. Again, all of this kind of helps demonstrate activist engagement in a litigation arena, in a policy arena, that feeds into the product liability, tort types of claims. It leads to high-stakes litigation, often high value, high dollar amounts in the litigation, and it's often very coordinated. The plaintiff's attorneys can be involved in it. They can help fund a lot of it. So there's a lot of coordination, a lot of overlap, and it's hard to say what the real goal is, whether or not litigation and plaintiff's attorneys being involved in the litigation is ultimately the real goal that these groups are after. I'm going to talk a little bit now about private nuisance and public nuisance and some of the litigation that's ongoing and some of the future trends that we're likely to see. It is definitely increasing. It is definitely evolving. And we can expect continued efforts in this regard. Private nuisance is the non-trespassory invasion of another's interest in the private use and enjoyment of land. It's also described as the defendant's unreasonable interference with plaintiff's use and enjoyment of property. It can vary from state to state, and this is one of the things that plaintiffs often use and makes it difficult for producers to be in different states because the laws are always different. We've already talked a little bit about temporary nuisance and how they can use that to bring claims over and over again. There are also differences in damages, the measure of damages, which allow them to either collect diminishment in value or the fair market value, but sometimes it can lead to other more costly types of damages. There are often very different statute of limitations involved, and then what constitutes unreasonable interference can be different in various states. In fact, various states often are different as to what you have to own to be able to sue in nuisance, whether or not you have to own the property or you don't have to own property to be able to sue in nuisance. We're seeing a lot of overlap into personal injury types of claims. Plaintiffs will attempt to assert personal injury, emotional distress, and medical monitoring type claims under the guise of nuisance. This makes it easier for them. They don't have to go through some of the discovery that they would otherwise go to, and they're using different kinds of theories, loss of use and enjoyment of property, to go into these quasi-personal injury types of claims, and it can be a very effective mechanism for the plaintiff's counsel. We're seeing this more and more in the agricultural, environmental, toxic tort cases where they're using these kinds of cases. They're trying to focus and use class actions, although that doesn't help with some of these quasi-personal injury kinds of claims because they can often be individualized. But they're still using mass actions, multiple plaintiffs, and using these private nuisance and public nuisance theories in these kinds of cases. And it has led in a lot of states to legislative responses where they try and get legislation to prevent these kinds of nuisance cases, and that can be a pretty effective tool for producers to get involved politically to try and get these kinds of cases or this kind of legislation done. An area that we're seeing a lot more of is public nuisance and climate change. And this is something to really monitor because there's going to be a lot more of it in the future. Public nuisance is defined as an increase in troublesome or offensive practices that annoy the whole community. It can be brought by the government. It can be brought by private parties, and we're seeing a lot more of this. The AEP versus Connecticut case, which we'll talk a little bit more about, is probably the priority because it's in front of the Supreme Court right now. Again, this is key litigation, and there's several of them that I'll flip through very quickly. But there's a lot more of it going on, and it's high stakes. Activists are very involved in it. It has significant environmental implications. And we've been very active as a law firm in briefing a number of these kinds of cases. These are suits that are brought up on a regional or even a global basis for typical energy-producing operations, saying that they're impacting the climate, they're changing the climate, and then causing injury and harm to individuals, which then they seek compensation for. So, again, if this sort of theory evolves and becomes viable, agriculture can expect to be included in these kinds of claims in the future. This is another one of these kinds of cases that alleges that Hurricane Katrina was more pronounced than it otherwise would have been because of what energy companies were doing. The Kivalina case is a village in Alaska that says they've been impacted by what energy companies and chemical companies have been put into the environment, and that has caused flooding, ice melting, and impacted the village. And again, if this continues, you can expect to see more and more of this kind of litigation. And from the consolidation perspective, companies and businesses that consolidate, that are bigger, will become more of a target. It becomes easier to focus on consolidated, bigger companies. There's fewer small folks running around that might be contributing to these climate change cases. So that's always an issue if you're looking at consolidation, and something that bigger companies will probably see more of. What are some things to focus on to try and avoid and minimize litigation in the food systems arena? Well, some of the things that you can do, and global business does mean litigation risks. There are multiple litigation risks. Consolidation, again, as you get bigger, as you become more global, there will be more risks that you impact and be exposed to. There will be supply chain links that are more pronounced in a global arena. The Japan earthquake is an example of what can happen from a supply chain perspective if you haven't focused and looked at alternative supply chains. And I think it all goes to big food being evil, big food being a target in the future. So what are some of the things that you can do to protect your brand, the company, and the industry? Get prepared. Develop meaningful crisis management plans. Anticipate emerging risks. Manage supply chains and control documents. And again, all of these are presentations in and of themselves. But there's information from insurance companies that a number of top-level executives feel like they're not prepared from a crisis management perspective, and that they don't have their hands around supply chain risk management issues. This is basically a diagram that's been put together when we've done some crisis management types of presentations before with PR firms. That is a good basis and a good model to look at when you're looking at crisis management type of planning. I'm not going to go into the specifics here. It's very much a multidisciplinary type of approach. But it's something to look at and focus on. And in the nuisance law arena, one of the things from a proactive perspective that can be done is to actually evaluate the jurisdiction that you're in, the nuisance laws that apply, and see if there are any things that can be done from an operational standpoint that might impact whether or not there would be any viable nuisance claims against you. So crisis management is something that's very important and to be proactive and prepared for. Another thing to focus on is assessing and managing the product supply chain. Again, I'm not going to go into a lot of detail here, but as a practical matter, you're only as strong as the weakest link in your supply chain, especially if you're upstream and something goes wrong. It will not be a very good defense to point to someone lower on the chain and say, well, they did something wrong. You need to be in control of it. You need to understand it because you're going to be responsible in the end for any problems in the supply chain. Managing documents, that is also very, very important. It's really critical. It's critical from a business perspective. It's very critical from a litigation perspective. Oftentimes, big litigation starts with, and a key component is discovery, and evaluating and gathering all the electronic information that applies to whatever the issue is in the litigation. As a company, if you are trying to figure out how to collect and manage your electronic information in the context of litigation, you've got a problem. You want to know ahead of time. You don't want to do it in the scrutiny and the crunch of litigation because a lot of mistakes can be made, and they can be very costly mistakes. What are some overarching legal issues that may be on the horizon? It's important to anticipate risk. As this slide demonstrates, a lot of folks are thinking that there's not enough attention being paid to evaluating and understanding what emerging risks are, what's out on the horizon, and more attention needs to be paid to evaluating from your company's perspective what are the risks, what's out there, and understanding what's on the horizon. What are some kinds of risks to look at, some things that may be issues in the future? We've already talked about nuisance. We've already talked a little bit about animal litigation. A couple that I'll spend a couple of minutes on: greenwashing, sustainability, consumer fraud and economic loss cases, and medical monitoring. Again, very quickly, greenwashing, claims about products or processes being green, being environmentally friendly. There is a lot more litigation involving these greenwashing claims, and you can expect there to be more and more in the future. As a practical matter, if you're big and you're trying to say you're green, that is not going to satisfy those who are really green. The smaller players have always felt they are green, and they're always going to feel like they're greener than bigger companies are. So expect to have a lot of pressure if you're a big and consolidated company and you're making green claims. It's just a matter of life. Even you are not going to have converts. The activists are not going to feel like, oh, you're doing a better job now. They're going to feel like you're saying and doing something wrong and trying to capitalize on being green when the activists are really the only ones who are green. So keep that in mind when making green claims. And again, we're going to see a lot more of this in the future. Here are some examples. It's also something the Federal Trade Commission is very much involved in, and you need to be cognizant of their guidelines, their enforcement, and the penalties they may issue if you're making green claims. Sustainability, we've already talked about that a little bit, but sustainability, more than just being green, it's also just not what you say, but what you do, how you act. And there will be more and more issues about sustainability, what happens with sustainable issues in the future. Water and use of water is going to be a big issue in the future. I just noticed last night reading the paper here in San Antonio that they've got water restrictions and water usage, and I think that's going to be a big issue for agriculture in the future going forward. Medical monitoring is another example where it could be an issue for agriculture. There's been a lot of work done to limit medical monitoring claims. Shook's been very much involved in briefing and litigation and articles on that, but it's coming back, and activists want to see much more in the way of medical monitoring claims for minimal type of exposures that may or may not have any kind of physical impact.